Good afternoon, everybody. Welcome. Welcome to Wetland Studies and Solutions BAT and Regulatory Updates webinar. I am Christy Blevins, the Director of Regulatory here at Wetland Studies and Solutions, broadcasting to you live from our BAT garden here at the Gainesville office. I'm going to be your moderator for the day. First, let's touch on a couple of housekeeping items. We encourage you to submit your questions throughout the program today in the chat questions function. We have two opportunities for Q&A throughout the program. We are supposed to have over 800 people joining us today. We had over 800 people register for this event, so we are really excited. Obviously, the topics today are just as important to all of you as they are to us. The seminar today will be recorded. The seminar itself, as well as the presentations today, will be available on our website. Additionally, at the end of the program today, you'll receive a certificate of attendance that you can use for your CEUs, so bonus there. We're going to start our program today discussing the northern long-eared bat. That'll be about the first hour of our program. That will be followed by our first questions and answers opportunity. We'll try to hit as many questions as we can. The second half of our program today will touch on the other regulatory updates, and then again have another opportunity for Q&A after that. So let's get started. I'm going to introduce the folks for the first part of the session. First up, we'll have Ben Rosner, the Director of Environmental Science here at Wetland Studies and Solutions. He's going to provide a background of the northern long-eared bat. Following Ben, we have Justin Curtis, Vice President at AquaLaw. Justin's going to give us the legal perspective of the U.S. Fish and Wildlife Services 4D rule and the uplisting. Following Justin, we have Julie Thompson-Slacum from U.S. Fish and Wildlife Service, Maryland Division Chief. Julie is going to explain the tools that Fish and Wildlife recently rolled out to make sure that all of us are staying in compliance with the uplisting. Julie also has Kathleen Cullen on the line as well from Maryland Fish and Wildlife. She's also available to help answer questions. Following Julie, we have Kim Prisco-Baggett, U.S. Army Corps of Engineers, Norfolk District. Kim is the District Chief of Special Projects and the Deputy Chief Regulatory Branch. Kim is going to give the Corps' perspective of process and timing for those folks that already have wetland permits and that will be asking for wetland permits. And last but certainly not least, we have Steve Hardwick from Virginia Department of Environmental Quality. Steve's the VWP Permit and Compliance Coordinator, and he's going to give us DEQ's perspective on process and timing. And then we will follow all of that with the first Q&A session. So let's get things started with Ben Rosner. Hi, Ben.
All righty. We'll see if we can get this going here. All right, perfect. Thank you, everybody. Appreciate you all joining us today. Really excited to go through this and talk about these important topics for everyone. So I'm just going to start off by giving some background here about the northern long-eared bat, just kind of set the table for some of the speakers to come and just kind of get everybody off on the same page here. So I guess number one, why do we care about bats? Like, why is this even a thing, right? So first of all, bats are very important for a lot of different reasons ecologically. Probably the way that you and I would be affected by the most is they're a big form of pest control. So they can go out and eat basically their body weights in insects on any given night. They also provide important seed dispersal functions. In some regions of the world, they serve as pollinators, so pollinating fruits and flowers that are important for agriculture. They're also an important prey source. So the northern long-eared bat, let's talk about the original listing. It was originally listed under the Endangered Species Act as threatened, and this was back in about 2015 because of some significant declines in their population. The reason for those declines is due to something called white nose syndrome. And white nose syndrome is a fungus that attacks bats primarily while they're hibernating, and it spreads pretty easily from bat to bat. It weakens them, so it helps them kind of, or causes them to go through a lot of the energy that they have stored up over the winter. And so when spring comes, when they emerge from their hibernation, they don't have the energy to fly off, to reproduce, and as a result, we saw these huge population declines of up to 97% or more in some areas. The white nose syndrome spreads pretty easily from bat to bat. It also may have been carried by spelunkers that would go into a cave, see bats, maybe get the fungus on their clothes, not properly wash their clothes, and go to another cave and spread it to other populations. In 2015, this was the species range that Fish and Wildlife had published. So the area in green, so it's found in, or outlined by green, I should say. So it's found in 38 or 39 states in the central and eastern US, and extends up into Canada. Those areas shown in red there were areas that were identified as white nose affected areas. So where white nose syndrome was present in these different hibernaca, these different caves where the bats were hibernating over the winter. And the orange is these buffer zones. The thing about the bat is in the summertime, it's really a habitat generalist. So it'll go out, it'll disperse across the landscape, it'll migrate away from where these caves are, basically those red areas on the map, and it'll disperse where there's suitable habitat. So pretty much anything that's forested, pretty much anything that has large trees, trees that are greater than 3 inches, and that have loose, shaggy, peeling bark, cracks, crevices, that sort of thing, anywhere where the bats can crawl up under during the day and roost during the daytime hours. And then they would emerge out at night and continue with all their bat activities, hunting bugs and such. So really, we do find it all across the eastern US, and if you've got, forest on a property, there's probably bats that are occupying that property at some part of the year. So in 2015, Fish and Wildlife had published this 4D rule, and Justin's going to get into some of these details as he speaks, but the focus of that rule was really these areas where the bats were hibernating during the winter, or where the females were having their pups during the summer months. And so this is the map on the Virginia Department of Wildlife Resources website that shows where these different important habitat features are located. So basically, it was under the 4D rule, you really couldn't do any work in those areas without first coordinating with Fish and Wildlife. You couldn't work within a certain distance of these caves where they were hibernating, or within a certain distance of what they call these known maternity roost trees. So really, for the average public, there were minimal restrictions on tree clearing, because most folks were working well away from these areas, and they could reliably say that they weren't having a take of these species because of the way the 4D rule was structured. Well, then the world changed, right? So in 2020, there was a court case, and again, Justin will kind of get into this in some more details. But basically, Fish and Wildlife had to go back to the drawing board and could no longer list the bat as threatened, but had to list it as endangered. So in 2020, they published the proposed rule as an endangered listing. And then in 2023, the final rule went into effect. So just a couple weeks ago on March 31st. And with that, they couldn't have under an endangered listing, you can't have the 4D rule anymore. So we're kind of in a new place now. So Justin's gonna dive into a lot more of those details for us. Here's now the range map for the U.S. So you can see it extends farther. There's some changes, particularly here in the coastal plain of the Mid-Atlantic and South here, but still really, still a wide range on the species. That hasn't changed too much. That hasn't decreased, but the populations have continued to decrease since that initial threatened listing, again, primarily due to white nose syndrome. And then coming soon, just in case you thought that northern long-eared bat was the only thing we were going to be dealing with, it's not. The tricolored bat was also listed or proposed for listing as endangered this past September. We're expecting a final rule on that in 2023, and I think some more speakers today are going to be touching on that topic. It's starting to show up in the Fish and Wildlife IPAC database. If you use that to do project screenings for potential for endangered species on your projects, you may now start seeing the tricolored bat coming up as proposed. And there was also some findings on petition in the last year or so for the little brown bat. So a listing there is being considered by Fish and Wildlife for that as well. So no known timeline there that I'm aware of, but just note that there's some more to come here down the road. And even though we may have some guidance here and things to act on here for northern long-eared bat, can't say if it's going to change with any of these additional species. So with that, I'm going to hand things over to Justin and dive into some of these details.
Thank you, Ben. Welcome, Justin.
All right. Afternoon, everyone. Get my screen shared here.
Looks good, Justin.
So you can see my screen?
Yep.
Excellent, excellent. So good afternoon, everyone. As Ben said, just going to go into a little more detail on some of the regulatory issues and the legal implications of the bat uplisting. So I'm going to start with first, just the big picture question: why the uplisting occurred when it did. I know some folks may think it's because Fish and Wildlife is mean-spirited people, but that's not actually the case. They listed the bat as threatened in April of 2015. As Ben mentioned, the 4D rule was issued in 2016, and it seemed, in my opinion, the very appropriate way of dealing with and addressing the threats to the bat, and it provided a relatively streamlined way to deal with the listing and to deal with avoidance. Unfortunately, there was some litigation, or fortunately, depending on your perspective, I guess, some litigation, some environmental groups that frequently sue Fish and Wildlife Service. They challenged the listing, the threatened listing, argued that it should have been endangered. The court agreed and found that the threatened listing for the bat was arbitrary and capricious, which basically means that it wasn't explained well enough. So the court directed Fish and Wildlife to go back and reconsider the rule. The court didn't require necessarily the uplisting to endangered, but for all intents and purposes, that's basically what it did. So as Ben mentioned, that ends up getting rid of the 4D rule. Just going to provide a little explanation as to why that is the case. So there is a common misconception that species listed as threatened are protected under the Endangered Species Act. They're not automatically. Now that was, as a practical matter, that was the case for many years because there was a 4D rule that applied the protections to endangered species, applied them to threatened species. That went away in 2019. So the 4D rule, what that does is it authorizes the Secretary of the Interior to issue regulations that are necessary and advisable to conserve threatened species. Basically, what that does is allows the service to afford some of the protections that to endangered species and extend them to threatened species. They typically now do that through species-specific 4D rules for threatened species. For the northern long-eared bat 4D rule from 2016, what it did is it prohibited purposeful take, intentional injury to bats, the northern long-eared bats, in almost every case, with a few limited exceptions, very limited exceptions. It allowed incidental take in most circumstances. We'll get into the meaning of that here in just a second, but incidental take, for example, I think the example that we're most familiar with is that the 4D rule allowed Tree removal, if you were a certain distance away from hibernacula, away from a distance from maternity roosts, and you're cutting down trees, and you accidentally, inadvertently cut down a tree that is hosting bats, then that incidental take would not be unlawful. Again, as Ben mentioned, that expired March 31st. So get to some of the implications of the uplisting. That gets us from Section 4 of the Endangered Species Act to Section 9. Section 9, with a few exceptions, prohibits take of endangered species. And again, the 4D rule only applies to threatened species. It does not apply to endangered species under Section 9, which is why that 4D rule expired concurrently with the effective date of the uplisting to endangered for the northern long-eared bat. So I know a lot of folks are probably familiar with this, but just for anyone that isn't, what is a taking of an endangered species or a threatened species? So it's a very, very broad term. I think sometimes characterized as looking at a species funny. Harass, harm, these are very broad terms. Any damage basically to a species or potentially some of its habitat is made unlawful as an unlawful take. For example, there was a case a few years ago out of Texas where the Texas Commission on Environmental Quality issued some permits for water diversions, which allowed third parties to divert water from rivers, which increased some salinity intrusion to those rivers, which stressed some endangered whooping cranes, which then caused some of them to die in the winter. Now, a court initially, district court initially found the Commission on Environmental Quality liable under the Endangered Species Act. It was eventually overturned on appeal, but it gives you a sense of the breadth of what can constitute take. Ultimately, the Court of Appeals held that in that case, that to take a species, your action has to have some direct or proximate cause to causing the harm, and harm has to be foreseeable. You have to it has to be reasonable that you could assume that what you did may possibly harm the species. And you can see how that would apply in the context we most often encounter northern long-eared bats with tree clearing. That in many cases, if you cut down a tree and you don't know bats are there, it's certainly foreseeable in many cases that there may be bats there. So you can see how you could potentially be liable for taking bats in trees through activities like tree clearing. Quick note on enforcement. So there are various mechanisms and means through which the Endangered Species Act and the take prohibition on the northern long-eared bat would be enforced. Fish and Wildlife Service, of course, has authority to issue civil penalties. Knowing, so intentional takes or harm to bats is a criminal offense, prosecutable by the U.S. Attorney's Office. I want to pause for a second in the third category, citizens. So, take is such a broad term, and there's the Fish and Wildlife Service and the Attorney's Office, U.S. Attorney's Office would typically be expected to exercise some enforcement discretion. Is an inadvertent take, does it rise to the level that they need to take enforcement action? The same considerations don't apply to citizens. There is a citizen suit provision in the Endangered Species Act, so you can imagine how this might apply to high-profile projects, particularly high-profile projects that involve tree clearing. You may have folks out there watching, and they may file citizen suit cases. They have to file a 60-day notice and say we intend to sue you, and after 60 days have passed, they can then institute a civil complaint. Also, federal permitting agency, if you have, your typical core permit would include special conditions, general condition 18 for nationwide permits, for example, imposes some obligations for compliance with the Endangered Species Act. So if you would violate those, you potentially be violating your permit as well as the Endangered Species Act. So you have multiple parties, the core in that example, Fish and Wildlife and citizens that could all potentially enforce against those types of violations. So now just a quick note on some of the implications and how to deal with the uplisting. So you're going to have more detail on the mechanics of how these work from Julie and Kim to follow, but just want to set the stage in the big picture here. and I break these down into 3 categories and 3 general situations that folks may find themselves in considering how the rule would apply. The first one is these non-federal activities, and that's, any activity that does not involve a federal permit. So if you were maintaining a utility corridor and you're not impacting streams or wetlands, you don't need any federal permit to do it. That would be an example of a non-federal activity. Now, what's important to bear in mind here is there is no safe harbor. The 4D rule provided you some safe harbor and made, in certain cases, incidental, accidental, inadvertent, unintentional harm to northern longyear bats was not unlawful. You don't have that safe harbor. That safe harbor has gone away. So in this scenario, it's important to evaluate your potential to affect northern longyear bats and act accordingly in accordance with the risk. Fish and Wildlife Service has provided some helpful guidance, which I've listed here, and which Julie will get into more detail about, to help you evaluate that risk. And at the end of the day, if there's an unacceptable risk that there may be some inadvertent take of northern longyear bats, so there's always the opportunity to apply for an incidental take permit from Fish and Wildlife. Second and third scenarios are if you are engaged in federally permitted activity. There's 2 scenarios here. First, if you are in the position where you may be filing an application for federal permit, Section 7 of the Endangered Species Act requires consultation if the activity you're applying for may affect a threatened or endangered species. So in this case, that would be triggered if your activity may affect northern longyear bats. That obligation to consult with the Fish and Wildlife applies to the permitting agency, so the Corps in most situations. Fish and Wildlife, and again, Julie's going to give you more detail on this, but Fish and Wildlife has issued an interim consultation framework that is intended to expedite that process. And I will just one quick note, even though Section 7 applies to the Corps and not to applicants per se, again, as I mentioned before, there are permit conditions that may apply some of those obligations and may put obligations on permittees or applicants as well. So just because Section 7 doesn't apply to individuals and applicants doesn't mean that you have no obligations by virtue of the uplisting. Also, you may have activities that were previously issued under a federal permit. So you have existing Corps permit, it involves some tree clearing. That activity is ongoing. In that case, there is an obligation or maybe an obligation for the permitting agency to reinstitute consultation. If that agency retains discretionary authority and the permit activity may affect the bat. So that would apply, for example, to Corps permits. The permittee, important note, so that, again, that Section 7 obligation is by default on the permitting agency. But that doesn't mean just because the Corps, for example, if they haven't reinstituted a consultation, doesn't mean you have protection for incidental take. Incidental take would still be a violation, even if you have a permit, you were in compliance with the 4D rule, and the Corps hasn't reinitiated consultation. We would expect, we have seen around the country a few examples of permit modifications. The Pittsburgh district and Baltimore district, Philadelphia district, for example, publicly noticed a new special condition with respect to the northern longyear bat for nationwide permits. Looking forward, just a quick note, the consultation framework expires April 1st, 2014. So any activity that will extend, that may affect the bat, they'll extend past that, would not be covered by this consultation framework that Julie's going to talk about more here in a minute. So basically, we'll be in a similar situation that we are today. At that point, we would expect Fish and Wildlife to issue additional guidance between now and then on how that transition will be handled. Lastly, before I hand it over, tricolored bat has been mentioned. There's a proposed listing for the tricolored bat. Just 2 points I want to make in the meantime. While the proposed listing is in effect, there is no prohibition on take. There's also not a Section 7 consultation obligation like there is for listed species. However, Fish and Wildlife's regulations do impose an obligation on permitting agencies to confer with Fish and Wildlife if the activity is likely to jeopardize continued existence of the species. And what that conference can do is it can provide some protection in advance. You can, for example, get an incidental take statement in advance that would not actually take effect until the listing takes effect. And so in that kind of a scenario, that would streamline the transition for those types of activities. So with that, let me hand it back to Christy. Thanks all.
Thank you, Justin. We always appreciate you keeping us out of trouble and clarifying things. Next up, we have Julie, which I'm sure everyone is excited to hear directly from Fish and Wildlife.
All right.
I see your slides. There you go.
All right. Can you see it?
I can see them. Yep.
Okay. As Christy said, I'm with the U.S. Fish and Wildlife Service. I'm out of the Chesapeake Bay field office, so I run our endangered species program, and I cover Delaware, District of Columbia, and Maryland. So I'm not from the Midwest region. That's actually the lead for this species and that developed this interim consultation framework and the determination key. But I'll try to, cover things as best as I can and answer your questions. And like Christy said, Kathleen Collins also on here. So, what I wanted to do is just to provide an overview of the process of how we're going to evaluate projects for northern long-eared bat now that it's listed as endangered. So to screen a project, you're just going to do what you've always done and go to IPAC. Hopefully all of you are familiar with that, but that's essentially the Fish and Wildlife Services screening tool for endangered species. If northern long-eared bat's on your species list, you can use the northern long-eared bat range-wide determination key. And then after you go through that determination key process, it's going to either provide a determination of no effect, not likely to adversely affect, or may affect. If you get the no effect or the not likely to adversely affect, you're done. So if you get that may affect, essentially we recommend that you reach out to your field office. Again, I only cover Maryland, Delaware, and District of Columbia, so it may vary, but for our states, we want folks to come to us because essentially those may affect determinations aren't always going to be, isn't always going to result in formal consultation. It could be that you give us more project information and it ends up being not likely to adversely affect. And essentially, the way that we determine the potential for take is determined by the project overlap with the bat presence buffers. So the different states are going to have a different layer. But essentially, the service is using 5-mile buffers around known hibernacula, 1.5 miles around known maternity roosts, and 3 miles around acoustic and mist net captures. And so this is the map that Kathleen developed for Maryland, Delaware, and District of Columbia. So any projects that fall within these buffers, you're going to get a may affect determination from the determination key. And just to explain these buffers, the blue circles are those are the hibernacula buffers, the orange are the acoustic and mist net buffers, and the brown points with the pink are the known maternity roost buffers. We only have a handful of known maternity roosts between Maryland and Delaware, and I think maybe a dozen known hives. So most of what you see are the mist net and acoustic detections, and a lot of them are along the Potomac. So for projects that don't have a federal nexus, we still want folks to use the determination key, and folks can use that through April 1st or up until April 1st, 2024. You're going to receive a consistency letter instead of a concurrence letter for that no effect and not likely to adversely affect. If non-fed projects get a may affect, they can use the services habitat management guidance, but essentially that's voluntary. But they can also reach out to the field office, and we can provide folks technical assistance on how to minimize impacts to your projects. So for projects that do have a federal nexus, a no effect determination means that there's no bat habitat or no activities that could harm bats. So essentially things like forest clearing. The not likely to adversely affect determination can be from negative survey results, which are valid for up to 5 years, or bats are present, but the activities aren't going to result in harm to the bats, or the project is outside of a buffer. For may affect, it's when the bats are present in the buffers that I showed, and there are activities that could harm bats, which I'll go into. So if your project gets a may affect from the determination key, again, check with the field office to see if it's a not likely to adversely affect, or if the interim consultation framework's even needed. So in other words, is there the potential for take? And when using the interim consultation framework, applicants will fill out the template biological assessment, which is found on the Region 3 Northern Long-Eared Bat website. And then the field office will provide a biological opinion with take coverage, so an incidental take statement. Traditional formal consultation will apply to any actions that are considered prohibited take under the interim framework, which I'll talk about next. So projects that aren't compatible with this interim framework are ones that occur within a 1/4 mile of a known northern long-eared bat hibernacula, ones that disrupt or disturb bats during hibernation, ones that result in physical or other alternation of a hibernacula's environment or entrance at any time of the year. If there's tree clearing activities within a 1/4 mile of a known northern long-eared bat hibernacula at any time of the year. And then if there's any cutting or destruction of known maternity roost trees or trees within a 150-foot radius around that known maternity roost during the pup season, which is June or July. Other prohibited acts are purposeful take of northern long-eared bats, intentionally excluding northern long-eared bats from buildings designed for human entry, or modification of buildings designed for human entry when the bats could be present, wind power projects, and then broad-scale aerial applications of pesticides over suitable forest habitat. And then I just want to show, this is a flow chart that we developed for our federal partners, mainly the Corps and our DOT partners, just to help them walk through the process of, with the range-wide D key and, essentially the determination that you get from that and what happens next. And I'm not going to walk through it, but I just wanted to point out that if there is a federal nexus and it's a transportation project, so it's funded through Federal Highway Administration or Federal Railway Administration, then those folks should be using the Federal Highway Administration programmatic BO and determination key. And I think some of our service folks are still working on kind of revising that. So this is probably the slide that people care most about. Essentially, once the biological assessment is completed, if your project's eligible under that interim consultation framework, applicants can just go ahead with tree clearing while we're working on the biological opinion and the incidental take statement. And then So timeframes associated with this interim consultation framework only applies to projects where northern long-eared bat's the only species. Traditional consultation timelines are going to apply when you have other species and there's the potential for adverse impacts to those species. Activities that will not be completed by April 1st, 2024, you can consult with us now, but if they're not done by that time, you're going to have to reinitiate. And then if sufficient information is provided to us through that biological assessment form, essentially the service will issue the BO and the ITS form within 15 days and consultation is concluded, so you're done. If more information is needed about the project through that biological assessment, we have 15 days to request that information. And then again, that we have 15 days after that, once we have the complete information to do the BO and the ITS. So the following is a list of stressors that can result in take but are covered under this interim framework. And I'm not going to go through the whole list, but generally it covers the removal of roosting habitat through activities like forest clearing and fire during the active season. But it also addresses disturbance that might occur during the active season that could be significant enough that it would result in bats fleeing occupied roost trees during the daytime. It also includes work on bridges and culverts that are greater than 4 feet in diameter, where northern long-eared bats are roosting during the active season. It also covers collision risk resulting from construction of new roads within 1,000 feet of documented habitat. And then finally, it covers use of waste pits and tanks containing water and contaminants during the active season. And then this is the list of stressors that may impact bats, but take is not reasonably certain to occur and would be not likely to adversely affect. And generally, that's the removal of roosting habitat outside of known maternity and hibernacula buffers, where tree removal occurs during the inactive season. And all of this list of stressors that will result in take and is covered under the interim consultation framework, and the ones that won't result in take can be found at our Region 3, the Midwest region, Northern Long-Eared Bat website. And it provides our rationale for these different things. So, but that's all I have. I'm sure you guys are going to have a lot of questions, and I guess I would just say, don't panic. At least in Maryland, Delaware, and District of Columbia, I feel like, we don't have a ton of buffers, and we really do want to work with applicants to just not panic and know that, we can work through all this. And I'm sure I'm going to get the question of what's going to happen next. Again, I'm not with the Midwest region, so I can't speak for them, but my guess is that they'll do another standing analysis to see if we could do, kind of prolong this interim consultation framework. But more, we'll kind of figure that out as we go along when we hear more from them. So, all right, that's all I have.
Thank you, Julie. That was really informative. Next up, Kim, if you are ready to share your slides. Perfect.
Okay. So good afternoon, everybody. My name is Kim Prisco-Baggett. I am with the U.S. Army Corps of Engineers. I'm going to talk to you a little bit today, kind of jumping off of the framework that Justin and Julie laid out and explaining how we're implementing that at the Corps for federal permits. Okay, So the first thing I want to mention is that we've gotten a lot of questions actually about how people should be running the D keys. Technically, for the core permit, our scope of analysis tends to be a little bit more limited. We would start with the area that is an aquatic resource that is proposed to be impacted due to the federal action, and then look at other activities that are only occurring because of that proposed activity and expand to cover those if necessary. So generally, there are some projects, a good example is solar farms, where we have a very limited federal handle. So for our needs, we only need the D key run within our scope of analysis. So just kind of throwing that out there. We do have kind of this small federal handle concept that was implemented in the most recent ESA regulations. So there is a potential path forward where if it is one of those larger projects and you want to try to do Section 10 and Section 7 through the Section 7 process, that is something that we can discuss. Okay, so what we are seeing, there are basically two categories of kind of processes here. One is for new applications. In this case, we recommend that if there is a consultant or agent, that they run the determination key. We're seeing that this really helps us because there's some questions on those determination keys that we really don't have that information included in the normal joint permit application. And so we would have to, ask for additional information and there'd be some delays. So if the consultant or agent can complete that, and when you submit your application, attach that consistency, the may affect consistency letter that pops out of IPAC, then that's super easy for us. We can go into IPAC, pull up that project number, verify that everything kind of matches the application, and go ahead and hit the button to send that in and hopefully get a concurrence letter. So the timing on that, that is dependent on what we get out of the system. So generally, we're asking our project managers to do general screening of applications within 30 days. So hopefully they will be able to do that IPAC determination key within that 30-day period as well. If we get a concurrence letter, then we have a 15-day wait period. If we don't hear anything from the service, we can move forward. If we don't get the concurrence letter, but instead get that may affect consistency letter, then we would have to go ahead and look at the interim consultation framework, see if that applies. And so then the timeframes are much more uncertain in that case. So the second situation is for previously issued permits where tree clearing within our scope of analysis has not been completed. So as Justin mentioned, technically, if you are not in compliance with the Endangered Species Act, you are not in compliance with the core permit. And that includes if you were in compliance when the 4D rule is in effect, and now we don't have that 4D rule to rely on, and so you are out of compliance at that point. However, the Corps often does not know when work has been completed or not completed. So we are putting the responsibility on the applicant for coming back to the Corps, letting us know if they're in this situation where they need to do some additional tree clearing in areas that were covered under a previously issued permit. And so once we get that notification, then we can work on reinitiating consultation. So again, same thing with this scenario, the timing's dependent on if the consultant does the key, and then what output letter we get from the key. Once that is complete, if the previous permit did not have a time of year restriction associated with it, and under this new scenario, we do have to implement a time of year restriction, then we will either have to modify the permit if it was an individual permit, or if it was a general permit, we can't modify general permits. So we basically have to re-verify the work under a current general permit. So that will take a little bit of time for us to go back through the old documentation, amend the documentation, and then issue a new verification letter. I'm not going to belabor this slide because Julie covered a lot of this already. The potential outputs from IPAC would be a no effect concurrence letter, a not likely to adversely affect concurrence letter. We would have that 15-day period in that case, but not a big deal there. And then, if we have a time of year restriction, making sure we work that into the permit. If IPAC spits out a may affect consistency letter, then we would look at the interim consultation framework. We would, in that letter, it talks about emailing the Midwest Regional Office with an email address. We have, in a couple of cases, emailed them and gotten approval to move ahead with a not likely to adversely affect. So getting that consistency letter does not always seem to mean that we have to go to the interim consultation framework. But we would do that coordination with the Midwest office, see if we need to do that interim consultation, or, you know, obviously worst case scenario, we might have to contact the Fish and Wildlife Service office and look at formal consultation. So I added a couple of slides here about the tricolored bat. This slide is quite literally the guidance that we gave our staff. So you're seeing the same thing that they're seeing. We're kind of working through this, so this information is good as of right now, but it may change tomorrow, but this is where we are currently. So each federal agency is required to confer with service when there is likelihood of jeopardy to the continued existence of the proposed species. Justin mentioned this, that jeopardy is a pretty high bar, but as an agency, we're not real comfortable yet with the tricolored bat and, you know, what activities affect it and to what degree. So what I'm recommending to our folks is to, at this point, handle this like any other consultation. So what we would do is make the best effect determination that we can, given the information we have. Generally, to make a no effect determination, that is up to the federal agency, but if there's any tree clearing, we're probably not going to be able to do that. The next option would be may affect, not likely to adversely affect, in which case we would submit a kind of informal consultation packet like we would normally to the service. So that might be a 60-day wait right there. And then, of course, may affect, likely to adversely affect. We would either be coordinating with the service office, or if we're pretty sure it's going to go formal, putting that formal consultation packet together. So if you haven't already seen it, the service did update the Northern Long-eared Bat survey guidelines to add some information about the tricolored bat. And in there, they talk about the potentially suitable summer habitat. So those are the things that my staff is looking for when making those effect determinations. And then they also include a couple of areas of unsuitable habitat. And that is all I have for now. Thank you all.
Thank you, Kim. That was very helpful. Next up, we have Steve to give us DEQ's perspective. Hi, Steve.
Just one moment, let me get this straight.
Yep, you're good.
Hello. Good afternoon, I'm Steve Hardwick. I'm the VWP Program Permit Coordinator and Compliance Coordinator. And I'd like to thank WSSI for hosting this regulatory update, and also appreciate all the people that have taken their time to join us here today. So DEQ, like the other agencies, is still somewhat finalizing the details of our procedures for coordinating the bat. Overall, I think we anticipate that the coordination procedures, once finalized, will closely resemble, you know, our process for coordinating other listed species as well. We sort of touch the long-eared bat coordination in two instances: the issuance of SBGPs on behalf of the Corps, and the issuance of VWP permits for state waters. We often do both concurrently, so it's, again, sort of trying to get all the agencies' processes together is something that would be very important for us to move forward with efficiency. For SBGP coordination, now, and I anticipate going forward, the Corps currently conducts the Section 7 coordination for SBGP. So in terms of our, you know, issuance of that permit, we anticipate that we will simply extend the coordination for the bat and any conditions that, you know, come from that coordination from the Corps just right into the SBGP. It will be conveyed into that permit from us. We don't think we'll be touching that aspect of it for the SBGP. For the permits that we issue for work in state waters, we must coordinate with the Department of Wildlife Resources. And currently, DWR has a GIS product, and it has mapping. It has some information regarding habenacular radii. It has some information about summer roosting trees for bats. And that product allows you to place your project, draw a project, and it does give you a list. Doesn't show you specific locations, but gives you a list of the absence or presence of certain different northern long-eared bat habitat and or presence of habenaculars. I reached out to DWR and spoke with them about that. And my understanding is that they're currently coordinating their final procedures with the Secretary's office right now, and that their final guidance will be released shortly. I believe that their product, will be used in some concert with Fish and Wildlife information that we receive for federal nexus permit, or if we have to do the coordination ourselves for whatever reason, then they will be in concert with that information. We will, as I said, we'll work within that framework when those sorts of things become more locked down in terms of the actual procedures. And, as always, we will work through that process with DWR, and if whatever that looks like in concert with the Fish and Wildlife Service information that you get through IPAC, to just close the species coordination thing as efficiently and quickly as possible. For consultants and other private individuals, to echo what Kim said, we certainly encourage applicants to access the available tools for coordination, to run the T keys, to work through all that information. I concur with her that, having gone through the T key training a couple of days ago, that the questions in there can be, depending on which path you go down by answering the questions, can become quite specific and esoteric, maybe very specific to your project. So it's a lot of information the DEQ might not have access to. And it can really save a lot of time if you sort of get that process rolling and get to a point with that process, whether it be a determination or a concurrence, and whatever the resulting package is, include that with your application to us. And as you know, that of course will help us to expedite the permit processing, and the species review is a big part of that often. So that's pretty much all I have for now. Certainly there'll be questions, and we are waiting for some information to move forward with a more locked down procedure. But in general, we are confident that we will be able to expedite our reviews that we do for the bat and other species as we move forward and get things a little bit more locked down. Thank you.
Thank you, Steve. That was really helpful, and I couldn't agree with you more. Some of those D key questions are really specific. We are going to open it up now for questions and answers, and if I could get all of our speakers from this part of the seminar to turn on their cameras, I would appreciate it. Hi, Julie, so I don't feel so alone. There we go. All right. Hi, Kathleen. Okay, so we have a handful of questions here to go through. I'm kind of going to just start at the top of the list for the speakers that are able to see them in our questions section, and try to throw them to a specific person. But by all means, we're all friends here, so everybody chime in if you got anything else to add. I'm going to start it off with kind of perhaps a heavy one, because that's at the top of the list. So for Kathleen and Julie, could you go into a little more detail on how to use the D key in IPAC, or perhaps where folks could go to find more information?
Yeah, this is definitely a Kathleen one. So go for it, Kathleen.
Sure. So let me see if I can share my screen really quick, and I can kind of walk you through, just show you where you go through. So basically you go into IPAC, and once you put your project in, if northern long-eared bat is on your species list, there's a regulatory review button that you can press, and that kind of gets you into all the tools. So
And Kathleen, while you're trying to share screen, we also pushed out a handout on the training sessions that Fish and Wildlife is providing.
Okay. Let's see, how can I get it to share my other screen? Let's see. Or pick
Yeah,
which
we're looking
screen.
at forest management, appendix A.
Your other. Monitoring. Okay. Let's get all this out of here. Okay, so can you guys see the IPAC page now?
Yep.
Okay. So I put a test project in. I've got northern long-eared on my list, so I can go into this regulatory review. And so you would request an official species list if you need it. And then the next step is to evaluate determination keys. And so the key that we're looking for is this northern long-eared bat range-wide determination key. So you wouldn't have started already, so it'll tell you if you want to use this, you can click a button to start it, and that will get you into the D key. So this is, I won't go through all of this, but this is how you would get there. And I do believe that on the IPAC page, there are some helpful videos that can help you walk through that process. So, and if you have any further questions, you can always email and I'm happy to help, but hopefully that's enough of an overview. Is that kind of helpful to kind of get you started, show you kind of where it is?
Thank you. Thanks, Kathleen.
Sure.
All right, so the next question, and sorry, I'm looking at two different screens, but so does forest clearing include forest management activities, or does it refer to deforestation? Again, I think perhaps this is a Fish and Wildlife question.
Yeah, I mean, it's anything. It could be, it's taking trees down. And I think the one slide I had kind of defined roosting habitat as, what was it, Kathleen? Like greater than 3-inch DBH. And just gives a more of an explanation of what we mean by roosting habitat. I don't know, Kathleen, did you want to add to that? But anything that's going to remove trees. The forestry gets complicated because that doesn't generally have a federal nexus. So that gets into those voluntary habitat modification guidelines. But for anything with a federal nexus, it's anything that's going to take trees down, we're going to look at.
Thanks, Joy. That's helpful. We have several questions here on some mapping components, and I know Kathleen has answered some. This question here, is there a NLEB reasonable certainty map for Virginia? I know you guys don't cover Virginia, but do you want to?
Yeah, so every field office did develop a reasonable,
No, go ahead, Kathleen.
Certainty of take map. So they do have one. It's going to be based on their occurrence data. And you'd have to reach out to them for any further details on that.
Yeah, I would say some states really don't have a lot of data. We knew this was coming, and we've just really have mined the data, through the different highway projects, wind power, you name it, and then working with the state. But there are some states that they don't have a lot of data, so they might be using a more coarse, buffer, like a layer that has just more coarse areas than we do. So.
Thanks for that. So this is a question, Kim, that I may direct to you. So will the new endangered listing affect construction projects that were originally considered under old regulatory rules that are currently in the development process?
So I'm not sure exactly what the question is. Are these projects that were previously permitted, or?
That's my assumption, yeah. They're already under construction. I'm assuming they were permitted under the 4D rule. Yeah.
Okay. So in general, any permits we issued relying on the 4D rule, the applicant is technically not in compliance any longer, and they should come back and reinitiate if the tree clearing has not been completed within our scope of analysis. So my understanding is that even if work is being done in those areas, if the habitat was removed while the 4D rule was in effect, then there is no further impact. So it all hinges on whether that tree clearing has occurred or not.
And so if I could ask an extended question to that, if all of the tree clearing wasn't complete, what remains, then that's what I would be processing through the D key, correct? So even though I may have had 100 acres of tree clearing, if I only have 5 acres that remain, then that's what I'm processing through the D key.
As far as I'm aware, that would be correct. I don't know, Julie, if you have, I'd be curious to know if you would agree with
that's
that.
definitely how we would look at it, because what you removed before, you had coverage under the 4D rule. So
Right.
whatever remains, you know, would have to be run through IPAC to see if there's a hit.
Okay. Okay. So this next question, is there any guidance as to the type of trees more likely to be potential roost trees? Since not all trees have cracks, crevices, etc. Oh, I just lost the question. So anyway, is there any guidance on the types of trees that might be more likely to have bats versus others?
So I would say with northern long-eared bat, they're just not as picky as Indiana bat. So I think, like, you know, we've had agencies come to us and say, well, we're going to tell you the species of trees, and we're only going to count the acreage of the trees that have exfoliating bark. And I would just say the species, they're not as specialized, you know, on what trees they use as Indiana bat. And then just another note, you know, for tricolored, they're even more, you know, habitat generalists. So I would just, you know, I think we can't get down to that level with northern long-eared bat and tricolored. Indiana, absolutely, but you know, I think we're just looking at mature forest essentially.
And again, anything over 3-inch DVH, right? Yep.
Yep.
So the next question here, this person is asking if they have an existing tree clearing permit in an area not on the habitat not on the habitat map, I have no bat obligation ?
Yeah, so even though you're not, and maybe Kathleen should answer this, but we also have a layer that we didn't show that has potential suitable habitat. And if you go through the D key and you hit that area, but not one of the buffers, you're going to get a not likely to adversely affect. So I would say technically, if you're removing forest habitat, you know, you should go into IPAC and run the D key. Kathleen, would you agree with that? Because they can't really see that other layer we have. It's just like, you know, you're going to run your project through IPAC and you're going to get that species list, and regardless, you know, so.
Yeah, going through the can help to tell you if it's going to be a no effect or a not likely to adversely affect if you're outside of those buffer areas. And it's depending on kind of the work that you're doing.
So this next question here, I think is also for Fish and Wildlife, and then I'm going to throw into Ben. So this question is regarding the findings for federal projects. If the project is located outside of known buffer areas, has bats present on a species survey, but is proposed to have time of year restriction on the tree clearing, would that fall under the bats present but no activities that harm bats, I assume not likely to affect, or would the D key lead to a may affect finding? I'm assuming it probably depends on their location and some of the other D key questions that they're filling out.
It can happen.
Kathleen, did you follow that?
I think so. So I think this would be a specific question that you would want to reach out to your field office for sure. But if you are going through the D key and you're not in one of those buffers, you will not get a may effect. So if you have survey data that says there are bats there, you'd want to consult with the field office because that would be, newer information that we'd want to take into account. So, but if you go through the D key, it might get you to not likely, which might not be the case. So.
Yeah, definitely a specific project. Right. Okay, Ben, I'm giving you this one. Homeowners Association periodically trims or removes trees throughout a 200-acre community. This particular scenario is in Fairfax County. So they remove trees for safety or other reasons, typically over the winter months. What would our obligations and process be before conducting such activities in the future?
All right, well, I'm not sure why I got chosen for this, but
I'm giving them a break.
Okay, this would fall under the voluntary habitat modification guidelines, I believe. So it's section 10. There's no federal action, so you're falling under those guidelines. So the proper process would be to follow those guidelines, go through either do the tree clearing. I think there were 3 options in the voluntary guidelines. So either doing the tree clearing outside of that time of year restriction, if possible. I guess safety is a concern here as well. There are allowances for safety, hazard to health and life. And then one of the options too is you can run the key and you can print that off with a copy of that map. It's the Fairfax County project, so that map that I had actually in my presentation, that's available on the DWR website. You can print that off and say, yeah, we're reasonably certain that a take is not going to occur because we're outside of a buffer area or a known maternity roost tree, and then go ahead with the clearing, kind of with that as the reliance. Any disagreement from Fish and Wildlife on that?
Sounds good.
No, that sounds good. I will note, and I didn't go through the list on my slides, but the folks that are working in Virginia and down south, it's a little more complicated because the bats are active year round. So, and I forget what that geographic area is. I mean, I assume it's like Southern Virginia, but
yeah, it's south of the James River in the coastal plain. So kind of, I'll say roughly east of 95.
So it's going to be a little more complicated there. But again, a lot of these projects are going to fall under the interim consultation framework, which is going to speed up things. You're not waiting 135 days to get a biological opinion so you can do your project. As long as you're outside of that hive buffer and maternity roost buffer. I guess I also wanted to add, like with the hive buffers, we would be looking at what's happening, like if there's hazard trees that need to be removed, I just want to make the statement that we're not stopping everything, in all of these buffers. And, we'll be looking at things, particularly in that hive buffer and the maternity roost buffer on a case-to-case basis, to evaluate whether take is certain to occur, because that's not always going to be the case depending on the activity.
We appreciate that to calm all of the panicking folks that might be on the call. Thank you, Julie and team and Ben.
I'll kind of follow up on that, Julie, with a question. I know we've got some folks, things from utility companies on here where they may be doing I think they call it danger tree removal, where they've got a tree that could fall on a utility line. That would kind of fall under this same category of, you could, because of that that exists as a hazard, you could do that at any time of year. Again, this not being part of the federal action.
Yeah, I mean, as long as it's not in that maternity roost buffer, and I am speaking from a Maryland, Delaware, and District of Columbia perspective. Let me just tell you, if my other field offices would get very angry with me if they don't agree with me. And there can be differences the way we look at projects, but for me, every project we look at, I've got to connect the dots, that it's going to result in take if, we're asking folks to do formal consultation. So you know, there's got to be that rationale or, you know, just that walking through that to assess that likelihood of take.
Very good.
Thanks. We have a few more minutes in this Q&A before we start the next part of the program. I have a question here for Kim. Certain Section 404 individual permits that were issued during the NLEB rulemaking period for which the 4D rule applied were conditioned with the time of year restriction on tree removal in forested wetlands. Using the new determination key, some of these projects would now receive a not likely to adversely affect determination with no time of year restriction for tree removal recommended. As the Corps encountered this issue, is it worthwhile to reinitiate consultation, and can a permit modification be considered under this scenario?
So yeah, I mean, definitely we can, I would recommend in that case, if the permittee has a consultant or an agent, have them run through the key, see if they do, you know, can get, well, they're not going to get to a positive outcome though. So I don't know, Julie, what would happen if was there any distinction when they run the key if they don't want a time of year restriction? They're still going to get that consistency letter, right? Would we have to run it on our end?
Kathleen, that's, I guess, a question for you. I mean, anybody could run it, but it would have to go to the Corps, that determination.
For the
Right.
final, yeah.
Yeah. Yeah. So they would get a consistency letter. I think if it was not likely to adversely affect or no effect, and then I suppose send that to you and then
Right.
use that.
So if going through that process, you know, you come out with an outcome of a not likely to adversely affect, and we can get that concurrence letter for that without a time of year
They're done.
restriction,
They're done.
then we can certainly either re-verify the permit if it was a general permit, or modify if it was an individual permit to remove that time of year restriction.
Yes. Yeah, if it's a not likely, they're not restricted.
So for an
I think in the areas that Ben mentioned where they're year round, I think it's popping out a time of year restriction for those areas.
Yeah, no, that's a good point, that folks will need to check in those southern areas.
Right.
I'm going to do one more quick question that I think will be quick to answer. This we've tagged it for you, Steve, although it might also be a Kim question. Will a previously authorized project under a DEQ GP with a Corps SPGP require recoordination for compliance with the new uplisting of the northern long-eared bat?
Well,
Yes.
I believe the Corps' SPGP might need recoordination. For the WP3, I'm not sure. It would depend on what the change was and our relationship, or rather the conditions that we had included per DWR as well. So could possibly have some recoordination for DEQ as well. Yes.
Okay. Thank you. Thank you all. We're going to jump into the next part of our session, some other regulatory updates. And then again, we'll have another Q&A at the end of the program so we can try and hit some of these we still have several other BAT questions to get to. So I'm going to, let's see, I'm going to share my screen. Thank you, panelists. I'll give you guys a break for a minute. See here. I shouldn't yet. Well, let me keep introducing folks. All right, so this next part of the session, we are going to cover WOTUS rule updates, changes to VMRC, permitting, orienting environmental justice, and NPDES updates in both Maryland and Virginia. So to cover those topics, We have Bob Kerr, who's going to touch on the WOTUS rule updates. Bob is our director at our Hampton Roads office. For VMRC and Orienting Environmental Justice, we are bringing back Justin Curtis to give us updates on both of those topics. And then last but not least, we have Jacob to touch on the NPDES updates in both Maryland and Virginia. So, and Jacob is our Southern Regional Manager for Environmental Compliance here at Wetland Studies. So Bob, if you're out there, if you can turn on your camera. Hey, Bob. I see you, but I don't hear you yet. There we go.
Try that.
Can you good, Bob? Can you hear me?
Yeah.
Okay, perfect.
All right, so I am unmuted.
You're unmuted.
I am.
You see your desktop. Oh, there we go. Perfect.
Can you see that?
Yep.
All right, great. All right, well, thank you for the opportunity to give folks a quick presentation of the new WOTUS rule. I'm going to move kind of quickly. There's a lot of nuance in this rule, so I just can't get to it in a quick summary. If you're wondering why are we going through this process again, there was a Supreme Court, or I'm sorry, there was two district courts that made rulings on what was called the Navigable Waters Protection Rule, or the Trump rule, came out during the Trump administration. That rule was vacated, and basically the Corps and EPA have been working to replace that rule. It came out this January, draft final to be effective March 20th. So it just went into effect. And in fact, I will talk to you about a court case decision that just came out early today as we were getting ready for the program. I'll touch on that at the end. There was a movement within Congress to overturn this regulation. President Biden just vetoed that a few days ago, so the rule is in effect today. What is the rule? It is a shades of gray kind of rulings, whereas the navigable waters rule was kind of black and white. It was more prescriptive. I think, frankly, we're going to be hashing some things out in the field with the Corps, maybe having some of those questions go up to the district just to clarify things, because again, there's a lot of nuance in this. If you have a jurisdictional determination, if it was under the Navigable Waters Protection Rule, you've probably already heard that it's not valid for use with permitting. If you have a JD issued to you since then, you can use it for permitting. So really, we're just kind of going forward in time from now. Any new delineations have to use this new rule. What hasn't changed? Well, what are called traditional navigable waters, territorial seas, navigable waters, in fact, interstate waters, those haven't changed. Impoundments of various types of waters, that has not changed. And importantly, the definition of wetlands has not changed. What has changed? How the federal government's looking at tributaries, adjacent wetlands, and by the inverse of that, isolated wetlands. And then this broad category of additional waters is slightly different than it was previously. This rule also has some exclusions. So there are specific things the federal government is excluding from regulations, so that's helpful. And there's a new term, significantly affecting, which kind of builds on the concept of significant nexus. And that's where a little bit of this complexity is coming in. Tributaries and streams, they're going to have to be relatively permanent, standing, or continuously flowing waters. If they are not, they are going to have to meet the significant nexus test. And that's where you get into, okay, well, what's significant nexus mean? It means alone or in combination with similarly situated waters in the region, they could significantly affect a chemical, physical, or biological integrity of traditionally navigable waters. So that's kind of how that is going to work. Another thing that has changed is in the area of intrastate lakes, ponds, streams, and wetlands. So those things that only fall within a state, they're going to have to meet one of two tests, the relatively permanent standard or the significantly affect standard. I just put a note on here that the rule says that they are not intending to be as expansive as they were back in the 1986 rules that really were in effect until about 2015. Again, we'll just have to work through that and understand where the differences are. One of the exclusions I mentioned was for ditches. The exclusion has some caveats. The ditch has to be excavated wholly in uplands. It can only drain uplands, and it cannot carry a relatively permanent flow, which really means seasonal flow or greater than seasonal flow. If it carries that, you would get into ditches that are jurisdictional. So what ditches are jurisdictional? Well, those that are cut through or draining wetlands, those that are tidally influenced, and then lastly, those with this relatively permanent flow. In a good way, the preamble to these regulations, which runs about 136 pages long, I think, has a specific call out that says maintenance of ditches does not require a permit. So that's some clarity we'd like to see. That's consistent with earlier interpretations of the rules. Things on the horizon, we understand just in talking ahead of this presentation that the Norfolk District is going to be coming out with a public notice explaining that jurisdictional determinations are going to be further delayed due to backlog and work. Really, the only way to get them in a scheduled manner is to submit them as part of a permit application, whether it's a nationwide permit, the SPGPs as we were talking about, or individual permits. And then Congress does not look like they have the votes to override President Biden's rule, his administration's rule, so the rule remains in effect. There's a Supreme Court decision that will be coming out sometime, quote unquote, early this year that may affect the rule. And then just today, I will mention that a U.S. District Court in North Dakota ruled in favor of 24 states, which includes Virginia, that the rule is now enjoined in those 24 states. So I'm not really sure what we're going to be doing tomorrow as a consequence of that ruling. Would probably be rolling back to the program that was in effect prior to March 20. And stay tuned is the short message there. So with that, thank you very much, and I'll turn it back to you, Christy.
Thank you, Bob. A lot of information, a very short period of time. Thank you. Justin, we are ready for your VMRC and EJ updates.
All right. Oh, did I go off of presenter mode all of a sudden?
You are a presenter, but we don't yet see
There we go.
slides.
See the slides?
Not yet.
All right, apologies for that.
That's all right. I had issues earlier.
There. All right, well, just go and speak to it unless it pops up here. I'm getting a thinky button. So I think it's a technical issue, hopefully not user error. But VMRC permitting, and apologies to anyone here that's not from Virginia. But quick update, some significant changes coming to upland non-tidal stream permitting in Virginia. So VMRC, for the folks that are aware, in Virginia, VMRC regulates impacts to non-tidal streams. And that authority actually predates our Virginia Water Protection Permit program, and it goes back to the days when Virginia still asserts ownership of stream beds. And so initially VMRC was given responsibility to permit uses and impacts of those stream beds. Then along came the VWP permit program overseen by DEQ and Steve Hardwick's folks. And so now we've got this duplicative permitting program for these non-tidal streams, and non-tidal streams greater than, with a drainage area greater than 5 square miles. So consistent with Governor Youngkin's initiatives and to streamline permitting as much as possible. There was an effort this last legislative session to eliminate the duplicative nature of some of these permits. So we had Bill HB 2181, SB 1074 that was passed. It was signed by the governor on March 22nd. That bill will become effective July 1st of this year. So as of July 1st, no VMRC permits will be required to impact a non-tidal stream under VMRC jurisdiction if the applicant obtains, excuse me, a VWP permit. So that will be a fairly significant change. Still nothing on the screen?
No, but Beth's gonna try and share. Oh, now we see something. I don't know if that's you or Beth, but we see it.
I'm sharing, Justin.
All right. Could you go, hey Beth, I'm sorry, could you go to slide 13? So this seems very straightforward, and obviously the intent is to eliminate the duplicative permitting. This is just to show you what the statutory text looks like. There are a number of questions that arise when you read the statutory text and query whether it does what was intended. So first question is, the statute says any activity conducted in non-tidal waters is exempted from the VMRC permit requirement. VMRC regulates activities and uses. So installing a utility under a stream and leaving the pipe there would be a use of the stream bed, for example. So it's not 100% clear. I think the intent was to not require VMRC permit for those kinds of undertakings, but so query whether it does that. It's not really clear. Also, bear in mind there are activities that involve crossing a VMRC stream that would not trigger a VWP permit requirement, such as an aerial crossing or a trenchless subterranean crossing. For those activities, at least under this language, you would still need a VMRC permit to install those types of utilities or crossings. Also, you can see the statutory language here. It requires DEQ to consider some of the factors that VMRC considers when it issues its permits. And most of those are generally fairly consistent. There are just a couple of very minor differences. For example, VMRC has to consider other potential uses of the stream bed. So it's possible that DEQ may be looking to update its regs to account for this. I will say it's my understanding that DEQ and VMRC, this language, this just passed. DEQ and VMRC sometime in the near future, and certainly before July, we'll be getting together to hash out the details here and hopefully answer some of the questions that arise from the statutory text. So long story short, it's a potentially positive change. It should streamline permitting for many folks. It should streamline permitting in a way that doesn't reduce environmental protection at all, because DEQ already is responsible for protecting water quality in streams. VMRC's interest primarily lies in tidal fisheries and shellfish beds. And so it'll allow VMRC to use its resources more effectively to protect the resources that it has jurisdiction over. So all in all, I think a very positive change. Next slide. So moving on to environmental justice. So quick note on environmental justice and a couple of changes. So environmental justice is a quick primer. At the federal level, we've got a couple executive orders. This is a matter of policy, not a matter of law at the federal level. So we have an executive order from January 2021, the first week of the Biden administration, which reinstitutes an executive order dating all the way back to 1994 in the Clinton administration that directs agencies to make achieving environmental justice a part of their mission. That executive order also includes a number of various agency-specific directives to incorporate EJ into different agencies' processes. At the Virginia level, in 2020, we had a couple statutes that were enacted that make it the policy of the Commonwealth. So this is now codified. It's not just a policy matter, but make it the policy of the Commonwealth to promote environmental justice. A related bill also passed in 2020, directs DEQ to further environmental justice in all of its permitting and regulatory processes. Next. So the definition of environmental justice is easy to comprehend. Fair treatment and meaningful involvement, I've highlighted those terms because they're the most important parts. So EJ is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, in environmental laws and policy and permitting matters. So as a concept, it's really easy to understand. Putting it into practice is much more difficult and challenging, which is why this concept first arose at the federal level in 1994, and here we are still trying to figure out how to implement it. Next slide. So earlier this year, or I guess late last year, EPA issued an interim, so this is draft guidance, it is not final, but draft guidance with recommendations to permitting agencies, so state permitting agencies, for example, as well as EPA, on how to implement environmental justice considerations and also Civil Rights Act compliance into their permitting decisions. Now, we could talk about both of those concepts for a long time. You know, we just discussed the definition of environmental justice. The Civil Rights Act of 1964 prohibits discrimination on the basis of race, national origin, etc. For the Civil Rights Act, violations, if there's a permit or regulation, etc., that has a disparate and adverse impact on a protected community or protected class without a legitimate purpose, that's a violation of the Civil Rights Act. So EPA's guidance is intended to try to characterizes these two concepts, EJ and Civil Rights Act, as complementary. In the sub-bullets here on the screen you see is a highly simplified version. So it's a lengthy document, highly simplified version of how EPA would suggest agencies go about incorporating and integrating those two concepts. Screening for environmental justice communities is step one. Evaluating impacts, including cumulative impacts, which is somewhat of a new concept for many permit programs. Engaging the community, which is an EJ concept that could also pay dividends for Civil Rights Act compliance. And then it recommends to agencies that they determine if the impact, if there's an adverse impact, which is an EJ concept, then if so, would that impact be disparate and unjustified, which again, Civil Rights Act concept. So the guidance is intended to bring those two concepts together. Last bullet on the slide here, there is one element of the guidance that has raised a few questions. Some statements in the guidance effectively saying that compliance with environmental justice guidance and environmental laws does not constitute compliance with the Civil Rights Act and vice versa. So that raises some questions about what exactly needs to be done to comply with all of these different requirements. Next slide. And turning to DEQ. So again, 2020, the DEQ was directed to make environmental policy or environmental justice part of its mission. DEQ has been working for a couple of years on how to implement that. Just a few weeks ago, they published draft guidance. The guidance is they're asking for informal comments as of before May 1st. Then they're going to take it back and make any revisions as necessary and reissue it later for a formal public comment period. Next slide. Just to understand what the draft guidance does, there's two key terms I want to mention. The first one is permits of concern. So the draft guidance would apply to, there's a list of permits. On this screen, I've just listed the ones related to water, which I think are most relevant to this audience. You can see there for each of the permits, there are thresholds, so it's not every permit, but I also highlight the bottom of the screen, bottom of that list there, the catch-all. So DEQ could apply the guidance to any permit on a case-by-case basis. Second is EJ community. One of the biggest challenges in trying to implement environmental justice concepts is how do you define what the environmental justice community is? We get a definition here in the guidance. It's a census block where greater than 30% of the households are low income, or any geographically distinct area where the population of color exceeds the state average. query what geographically distinct area means. I think that raises some questions. Hopefully, will be hashed out in the guidance before it's finalized. Next slide. So just want to show, this is a flow chart that's drawn directly from the draft guidance. It just gives you a sense of how DEQ would go about implementing the guidance, and again, for permitting processes for those permits of concern. So when a permit application is received, they would first screen for whether or not it's in an EJ community. If it is, they would enter it into, they would document it, enter in a database. Second, they would determine whether or not it's a permit of concern. If it is, then they would go through meaningful involvement, and there's some guidance in the guidance that describes how they would do that. Basically, it's additional outreach to members of the community. And then after and one thing that's important to bear in mind with DEQ's guidance, which is a little bit different from some of the EPA policy, is the onus here is really on DEQ to go and engage in meaningful involvement and to take these steps, which is somewhat different than some of the guidance that you get some other places. So after DEQ is engaged in meaningful involvement, they would take that information they've gleaned from the community, as well as their evaluation of the application, determine if there's going to be a disparate or disproportionate impact. If there is, that's when the fair treatment concept kicks in. In DEQ, the guidance recommends a number of steps, including additional mitigation, additional permit conditions, additional prioritization for monitoring and enforcement to ensure that the community, the EJ community, is treated fairly, and all that then will be documented for the record. All right, last slide. So just to wrap up the EJ discussion, EJ has been a concept at the federal level, policy at the federal level since '94. It feels a little bit like waiting for Godot, trying to figure out how to implement it. Although it does seem like there's a momentum, and this concept that's been percolating is actually going to have more practical effects going forward. Although this is evolving and changing very rapidly. So just a couple points of quick advice or recommendations for what to do in any permit application scenario. These days, it's very important to screen for EJ communities in the area. I should say it's very prudent to screen for EJ communities that may be affected by an activity if you're involved in a permit application. Meaningful involvement, again, although the responsibilities, at least in Virginia, are primarily on the agency, that doesn't stop anyone. It's wise to go about contacting the community and engaging them and doing that outreach on your own, particularly before the application is filed, but potentially after, if you have an EJ community. Fair treatment, bearing in mind that the agencies are going to be looking at whether or not your application, your activity, it treats the community fairly. It's a good idea to do that evaluation yourself at the pre-application stage in particular. Just bear in mind, the potential for disparate impacts, and particularly that's an issue in site selection. If you've got an activity that the site can't be changed, a discharge from a wastewater treatment plant, for example, those are the kinds of scenarios where evaluating whether or not additional mitigation, voluntarily proffered mitigation, or other actions may be appropriate to avoid potential for disproportionate impacts. So with that, hand it back to Christy. Thanks, and apologies for the technical glitch.
No worries, Justin. That's why we're all here in the green room. Thank you very much for those updates, Jacob. How are you?
Good afternoon. Thanks, Christy. Everybody able to see my screen now?
Yes. Yep.
Perfect. Well, thanks for having me. As Christy said, I'm Jacob Bucher, Southern Region Environmental Compliance Manager for Wetland Studies. We wanted to follow up on an update for the Maryland Construction General Permit, which we highlighted potential changes to permit requirements during our regulatory update in 2021, actually. So since 2021, a few things have changed. The Construction General Permit, referred to as CP20, was put into effect at the beginning of this month on April 1st, 2023, with a variety of changes being made from the previously in place permit, which expired actually at the end of 2019. So today we're just going to run through some important details, very high level, and some significant changes with the implementation of the new permit 20 CP. So right off the bat, what does this mean for current permit holders? Any permit holders that have active projects that plan to continue to be active need to apply for reauthorization via a new notice of intent under the new 20 CP by September 30th, 2023. And additionally, there's a few updates to the NOI application and the approval process, a few more questions on the NOI application, and then on the approval process, you have to have approved E&S stormwater plans and a SWIP developed, if applicable, before you can start the public notice period. So this is going to slow down the approval process of NOIs, where previously you could submit it without a plan approval. We now have a list of approved chemical additives for sediment control approved by MDE, along with a process in place for obtaining approval for the use of cationic polymers. There's been a change in the inspection frequency. Previously in the CP14, you could do inspections once a week and within a 24 hours rain event. Now under the CP20, you can do two options, once every 4 business days or once a week and after a quarter-inch rainfall. Projects that discharge to a tier 2 water will be required to perform inspections at least twice weekly, so increased inspection frequency for tier 2 projects. Stormwater pollution prevention plans are now required in certain activities and conditions. So some of these activities are use of chemical additives, as stated earlier, being approved. Construction activity that will disturb material or soils with known contamination. Use of controls associated with any pollution prevention activities, or where you're sharing permit-related functions between and among operators on the same site. Additionally, if there's a project under Title IV where you can be exempt from E&S for stormwater plans, you have to complete and develop a SWIP in place of those plans. As hinted on with the increased inspection frequencies, there's also additional tier 2 requirements for projects that discharge to tier 2 waters. So some of these requirements are turbidity benchmark monitoring for any dewatering activity or any discharge from offsite. Anti-degradation checklist, which needs to be filled out during your NOI process and submitted with your NOI application. An increased stream protection zone, along with an increased inspection frequency, which we already touched on. Big change for some of the builders in Maryland is going to be, previously a builder could work under a developer's permit without pulling their own permit, but with the new CP20 permit redefining who needs permit coverage, all operators and permittees, regardless of acreage for a common plan project, will be required to obtain permit coverage. This is by no means a comprehensive list of all new permit regulations or changes in the permit, but a highlight of some of the key changes. If you have any questions, comments, concerns about the Maryland Construction General Permit, please feel free to contact Matt Elliott and Josh Howard. Emails are there for you. And then as far as for the Virginia Construction General Permit, also known as the VIPDES program, there are no significant updates at this time, but with the permit expiring in June 2024 and the changes we've seen with both the EPA's permit and Maryland's Construction General Permit, we expect to see some changes, which we will keep everyone up to date on as they come. Thanks. Enjoy the rest of your day.
Thank you, Jacob. All right. Thank you guys all for those regulatory updates. If I could again get our, I guess, all speakers, if you don't mind turning your cameras on. We have tons of questions that we will try to get through as much as we can in the next 15 minutes. I'll give folks a second to turn their screens on. There we go. All right. Welcome back. Okay, so there's a lot of questions here for Fish and Wildlife. I'm going to try and spread this out as much as I can, but anyone is welcome to jump in. There's several questions about kind of, is there a minimal amount of tree clearing? So I'm going to ask a couple of these questions all together. The first one is, can trees with 3 inches DBH or greater be trimmed or limbed, but not cut down? There's another question here about, is there a de minimis number of trees that are considered clearing, say 1 tree or 10 trees that may not, trigger the need for a D key? And then similarly, would this process affect those that may have a single tree in an urban area? I don't know if we really talked about urban trees. So I'll kind of throw those 3 questions out to, I guess we'll start with Fish and Wildlife.
Kathleen, do you want to start with the limbing? Because I know that's been discussed on our regional calls.
Yeah, so I think, so I believe it depends really on the acreage, right? So the limbing is not so much of a concern for individual trees, and it's not really so much the tree size. It's going to depend if it's in those buffer zones, if it's going to have reasonable certainty of take or not. So with those, just start with the D key and go through there and see kind of what determination you get. And then for the minimal clearing ones in the D key, anything under 10 acres, I believe, is going to be not likely to adversely affect if it's outside of those buffer zones. And then for our field office, Maryland, DC, and Delaware, we are looking at anything greater than 15 acres. And again, that's outside of those. Well, that's inside of the buffer zones, but not the maternity or the hive ones. So that's to just go through the key, and then we'll kind of guide you through there.
Yeah, and like District of Columbia, like most of our bats are at Rock Creek Park. So essentially, there's really no acreage threshold there because everything's in the buffer. So.
Okay, thank you. I'm actually going to throw this next question, I think, to Justin to start. So the question is, I think I heard that the review process is not required for projects without a federal nexus, such as on private land or state land without federal funding involved. I also heard that there could be penalties from Fish and Wildlife for incidental take. Could there be a penalty for incidental take if review isn't required?
Yes. So the general prohibition on incidental take applies irrespective of the activity. The Fish and Wildlife guidance, the D key, is very helpful for gauging your risk and determining whether or not you need to take additional action, take additional avoidance measures, et cetera. It's helpful for that. It would also be helpful, from a liability perspective, as we talked about a little bit ago. Foreseeable impacts or foreseeable inadvertent take is potentially subjects you to liability. My suggestion would be that if you did everything that Fish and Wildlife suggested, and you used the D key and it said you're not likely to, you will not affect the northern long-eared bat, then probably any incidental take that ended up happening wouldn't be foreseeable, and therefore not subject to liability. But that's certainly theoretically at least a risk anytime you do any activity that has the potential to affect an endangered species like the northern long-eared bat.
Okay. Thank you, Justin. If a project is within a 3-mile radius of a known northern long-eared bat location, can a project be excluded from the time of year restriction if a negative bat survey is obtained and approved?
Yes.
And if I could also ask, so if somebody runs a D key, they get a May effect because they're within 3 miles, and then they do a bat survey, which gets approved, they can come back and re-coordinate, correct?
Yeah, I mean, Kathleen, that's how you're interpreting it, right? Anytime we have negative survey data, we've got to go with that because that's the best available information. So yeah, it would go to a not likely to adversely affect, and then they're done.
And I would just add, we'd want to make sure that they're following the survey guidance.
Yep.
Yeah, I mean, anytime someone does surveys, we have to look at the survey plan and concur with it. And then we also have to concur with the results.
And there was a question down here about, so if you guys could also touch on, in regard to the surveys, the certification, the people that are able to conduct those surveys. And then there was a question here as well, do you need to be an approved surveyor to say that an area does not have suitable habitat, as opposed to automatically assuming suitable summer roosting habitat?
Yeah, I mean, we're always gonna want an approved surveyor to do the work. And again, it's, you know, that's suitable versus unsuitable habitat. It's a tough one with the species. So if it's in the layer that we have that I talked about, which is essentially for our area, we're using like a FIDS layer. So that's like mature deciduous hardwood forest. And then of course there's the buffers, but for Maryland and Delaware, we don't have an approved surveyor list right now. We're working with those two states to come up with criteria and then develop a list. So if you have a project in one of our states, what we would do is just give you the West Virginia, Pennsylvania, or Virginia surveyor list.
Okay.
And we would be fine with folks using them.
Okay, thanks, that's helpful. So this question, is there any guidance for projects that formally met nationwide permit conditions for non-reporting or no PCN? Will a PCN in consultation with Fish and Wildlife always be required? Will the Corps need to do this consultation, or will the permittee be able to consult separately?
So for our general permits that have a PCM threshold specified, if you are under that threshold, then technically the applicant can make the decision whether they meet the rest of the conditions associated with that permit. And so ESA is one of those conditions. And if there may be an effect to an endangered species, then technically that triggers a PCM, even if their activity and impact thresholds are under that PCM trigger. So hopefully that helps. If we get a submittal that technically is under that PCM threshold, we try to call the applicant and say, do you need a letter from us, a written verification from us, or, you know, are you comfortable taking that risk and proceeding on your own? But generally we would recommend that, you know, it never hurts to get that verification in writing, and that allows us the chance to make sure that you're compliant with all those terms and conditions, and you can rely upon that verification then.
Okay, thanks, Kim. Question here, northern long-eared bat time of year restrictions also, the question is, do they also apply to private utilities? This person is considering Dominion Power clearing limbs around power lines. Ben kind of touched on this earlier, but.
Kathleen, do you want to answer this?
Well, I would say if there's not a federal nexus, it kind of goes to that voluntary process, and we would recommend at least, you know, avoiding June and July in summer habitat, and then the swarming and staging area if it's near hibernacula. So I think it's going to depend on where it is and what state you're in. Just check with your field office and they could kind of give you those best conservation measures for the time of year restrictions. But it would not necessarily be the whole active season.
Okay. Yeah, let me scroll down here. Sorry, I'm just trying to sort through all these. If the scope of analysis is reduced to federal nexus areas, tree clearing might not be included. How should these projects ensure their tree clearing is covered under ESA? And I'll pose that to Kim.
So as far as ensuring that a permitted action is covered by a core permit appropriately, we're really only concerned with tree clearing within our scope of analysis. So I don't know if Fish and Wildlife Service wants to talk about more of that Section 10 responsibility on the applicant outside of our scope of authority.
Yeah, so would that then be a situation where you're running both? you're running your DEQ for the core permit area and then also adhering to the voluntary guidance outside.
Yeah, you could run the IPAC for both, and then depending on the determination you get, follow that voluntary guidance.
Okay. Yeah.
So the other option is we can accept a DEQ that is run on the larger project. But if that, because of the size of tree clearing, triggers a time of year restriction, then we would be required to include that time of year restriction as a special condition of our permit. Whereas if you run the DEQ on the smaller scope of analysis that falls into the core jurisdiction, if that reduced acreage means that no time of year restrictions required, you wouldn't have that condition on your permit. So we can accept a key, whether it's run on the smaller federal handle or the larger project, just as long as the applicant understands that that may trigger additional special conditions.
Okay, thanks, that's helpful. This next question is about desktop analysis. So maybe Kim or Bob, you guys could touch on this one. What is a generally reliable way to conduct a desktop analysis of a tributary ditch to determine whether it has significant nexus? CORE previously had published a general guide that was helpful in looking at various situations of stream orders and photos of ditches. Will another be following soon?
Ditch is kind of a 4-letter word. Yeah, you know, I think one of the, and again, because now it looks like we're in a complete holding pattern right now. So if you're looking for an AJD, I actually just sent an email to my staff while we were on this call saying that we are prohibited from issuing any AJDs until further notice. So our headquarters is working with DOJ to determine what this court ruling means for us and how we can proceed. But in general, most of these JD rules do have a commonality in that if you're looking at like old USGS quads or an NHD layer in GIS, if you're tracking that location to an old blue line, you can generally determine that that's probably going to be jurisdictional regardless of what rule you're under.
Okay. So if I could ask you, I know Norfolk Core was getting ready to publish a public notice perhaps next week on JDs. Is that now maybe on hold given this ruling?
So probably not actually. We may have to modify what we were planning on putting out. But that public notice and what Bob mentioned about kind of deprioritizing not only JDs, but also even delineation concurrences, I think we may still move forward with that. So based on workload and the way that we're currently being funded, we've kind of already realigned our priorities to permit actions. And so I think the public notice will probably basically just point to that kind of slight change in course, that for the quickest response from us, submitting a permit application, or if it's a all upland call, then requesting a no permit required. Now, that piece we won't be able to act on at the moment because that would require an AJD, unfortunately. But a lot of permit applications, we can either do a delineation concurrence on or a preliminary jurisdictional determination, and neither one of those are impacted by this court decision.
Okay. Okay, thanks. Breaking news. Breaking news.
Yeah. Kim, which two are not affected by the court case? PJDs, you said?
Preliminary jurisdictional determinations, because those are not based on the current jurisdictional rule in place, and wetland delineation concurrences.
Oh.
So that's kind of what we use for a lot of general permits. We don't really require that you get a JD ahead of coming in with a permit application. If you submit a wetland delineation, then we can call that federally complete. And then based on our scope of analysis and our level of comfort with the delineation, we can go ahead and move forward with a permitting action.
There's one other thing for people to be aware of. There's the Corps and EPA have just put out a manual, much like a wetland delineation manual for, I forget the waters, I guess it's ordinary high watermark determinations. And that's been something that's been a long time coming. It's got a 1-year testing period that it's undergoing now. So probably late next year, there may be a manual out that would help to clarify both kind of the field procedures, but also like the question was asking about desktop process. I think the other thing is if it's an intermittent stream on a USGS quad sheet, you could be safe to assume, I think the Corps will take a really hard look at calling that anything but jurisdictional. Because this whole concept of relatively permanent includes seasonal, and that's similar to what we've been doing under the Rapanos rule since 2008 or so. And the general rule of thumb is if it's groundwater driven, it's considered relatively permanent. So if it's only a conveyance that is receiving runoff immediately after a precipitation event, then typically they weren't regulating them. It gets complicated because if you've got marginal flow and ordinary high water marks on the feature, the question became, is the Corps going to regulate it or not? And that's kind of always been the vagaries of field conditions and what set of rules we're under. Is that fair, Kim?
Yeah, I would agree. We've had some people claim that we should be taking a very hard and fast. If you don't see the water flowing, then it's not jurisdictional. But especially, well, if we can proceed with the current rule at some point, that one especially talks about subsurface connections. So even if you don't see it flowing on the surface, there might be that subsurface connection. Hard to say, and I don't know where we're going to go on approved JDs moving forward with this new court decision. So,
and with that, I wanted to mention Maryland, Delaware, and North Carolina were not included in that court case. So the only one that seems to be, in our neighborhood that was affected is Virginia.
Perfect.
Keep it current.
Well, I just want to say thanks again to everybody who joined us today for our seminar, and a special sincere thank you to all of our panelists. We really do appreciate your time. It's not easy talking in front of hundreds and hundreds of people, so thank you all very much. We really appreciate it. We know you're all very busy. And again, this was recorded, so you guys can access the recording later when you're looking for something to do in the evening. You can watch it again. Thank you again, and we will close out. Thank you so much.